Here's a scenario we have encountered more than once. A couple spends significant time and money working with an estate planning attorney to create a thoughtful plan, a will, a trust, carefully considered beneficiary designations. The documents are signed, stored, and largely forgotten. Years later, one spouse passes away and the family discovers that several of the most significant assets, a brokerage account, the bank account, the vacation property, didn't have their titling or beneficiary designations updated. Today, we're going to talk about how your assets are legally held, why it matters more than most people realize, and how to make sure your titling and estate plan are actually telling the same story. So Spencer, today we're going to talk about how do we title assets, and really this is to make sure that those titles align well with our estate plan. We may work with an estate planning attorney, get a plan document set, say, okay, this is great, this is exactly what we want. If we go away and we don't make any changes to the current accounts that we have, then when we pass away, those documents really didn't do anything. So talk us through some of the most important ways, 6 different ways that assets can be held or titled.
Yeah, so the first one is we have retirement plans, and this would be 401k, 403b, 457, IRA, Roth type accounts. These are accounts that have some benefit from a tax standpoint. They're set up by and large within the ERISA framework in the early 1970s, and you're really not going to have much of a decision here. It's going to be you're going to be the owner of that. The key decision that you have is who do you name as beneficiary? So we'll talk about that here in a moment, but those beneficiary designations are critical. So again, retirement accounts would be the first way. The second way would be you hold those assets in trust. Again, we're not going to go into great detail in this part of things, but if you name a trust as, or if you title those assets as being held by the trust, then the trust document is going to govern who makes decisions on those assets and who any successor decision maker might be, and then where those assets go over time. So once we have those assets retitled as being owned within a trust, then things are simplified, in many ways. The 4 that we're going to talk through, though, in terms of how we may hold an asset and what each one means, are these non-qualified accounts. And the first way among these 4 particular would be sole ownership. Mm-hmm. So just as it sounds, there's an individual owner here, entirely owns this asset. At passing, the asset will then transfer to an heir. Now, the heir could be named as a transfer on death or a payable on death beneficiary, which can keep things quite simple. But it's that individual that owns the asset, and typically the heir is going to receive a step up in cost basis there. So, this is again the simplest way. Everything's going to flow to that individual's tax return. If he or she files with a spouse doing married filing, joint tax filing, then those any kind of income or gain or what have you on that account will flow through to that joint tax return there as well. So that's the first one.
Okay.
Second one, you have joint tenancy with rights of survivorship. So this would be the classic joint account. Most of our clients who are holding joint assets in the state of Tennessee, it's going to be this joint tenants with rights of survivorship. Basically what this means is you hold the asset together. When one person passes away, the other person becomes the owner of the entire value of that asset, the entire asset itself. So it's simple and fast. It's popular, especially among married couples, and you can still name a beneficiary there. So you could still name a payable on death or a transfer on death designation there. It would just be after both of the original owners pass away that designation would take shape. So we oftentimes will have a joint account that will be held joint tenant with right of survivorship between spouses. First spouse passes away, that second spouse becomes the only owner, and then we still have that TOD designation in place, that transfer on death designation in place that would go to the next owner there. So those would be probably the 2 most common that we see. A third one would be the tenancy in common, or TIC. So tenants in common, this would be more typical for, say, brothers who might own property or sisters who might own property. Each owner holds a defined percentage of the asset. It's often 50-50, but it doesn't have to necessarily be 50-50. Right. What this allows essentially is if you have 2 brothers, let's just say that they own a piece of property. One passes away. Well, let's say they owned it equally. The one who passes away, he might have his son and daughter as the beneficiary of that. And so it doesn't automatically mean that just because he passes away, his brother takes the entire set of resources, which would be the joint tenants with rights of survivorship that we just talked about, that kind of situation. Instead, that joint tenants in common, you have the amount of asset that's held there when one person passes away goes to his or her beneficiaries there. So this keeps things relatively straightforward and clean, especially when you have assets that are held among parties that are not married. And just putting a bow on this, you do have that person who has passed away. Those resources would either be directed by whatever designation would be set up, or more commonly would pass to their estate and then be pushed out, via their estate there. Finally, we have tenancy by the entirety. And this is one of those designations, or this is one of those ways that property can be titled that many people have never heard of. So the benefit essentially with tenancy by the entirety is that if you have a creditor of one spouse, they can't come after this particular asset because it's owned by both in the entirety. And so there's legal protections, around that. So it's useful for primary residences in states where it is available. It's just not available, everywhere there. So that's, again, we come back to the 6 different ways that they can be held. And those are the ways that we would look at it.
Okay. So we come back to this and the importance of it because there is this hierarchy. Mm-hmm. The beneficiary designations are going to supersede estate plan documents. Mm-hmm. Talk us through that a little bit more. Why are there those hierarchies of control, and why is it so critical that we not only write the beneficiary designations correctly the first time, mm-hmm. but review them regularly?
Well, this is one of those things that it's not uncommon that you would have different beneficiaries named in a will, mm-hmm. and then for your IRA or 401k or what have you. Sometimes it's just from neglect. Mm-hmm. You might have your will drafted and you haven't updated it for 30 years. And in your will, you name your spouse, but you have no idea that you're going to have kids. Mm-hmm. So just spouse, everything goes to spouse. Okay. Well, then let's just say you have kids and later on you're getting closer to retirement and you look at your beneficiary designation and you say, okay, I've named my spouse, but I want my, 4 kids to be contingent beneficiaries here. So you update that on that particular account. Well, now you have those contingent beneficiaries. You've not updated your will though. Now, in practice, the courts are going to help you in most cases. In this particular situation, if your spouse has predeceased you, then the court is going to look and say, okay, well, yeah, we're going to pass those resources on to your 4 children. But there are situations where you might have named, say, a brother or a sister even before you got married, to some of these retirement accounts. And you need to really have updated those beneficiary designations to make sure that everything is going in the same direction. So the titling, though, is really critical. The beneficiary designations, especially on retirement accounts, because they will supersede what's in your will. Mm-hmm. Let's just say that you wanted those resources at one point, you wanted half of those resources to go to one particular charity. And so you named that charity in your IRA. And then let's say you had 2 kids and each of them were going to be contingent beneficiaries receiving 25%. Let's say that you had named your spouse as primary beneficiary, and then that was the contingent, way that you were going. Well, let's just say a couple of years later, you said, I don't love that charity anymore. Mm-hmm. It's not, at the top of my list into, who I want to give resources to. So let's say at that point you update your will and you're going to give everything to your kids, in the will after spouse passes away. Well, if you still have the beneficiary designation in that IRA as 50% to that particular charity and then 25% to each of your kids, that beneficiary designation is going to apply to that account, even though you've more recently updated your will. So we got to have, especially with beneficiary designations on retirement accounts, those are really, really important to update and make sure that they're in line with your estate plan because they will supersede the will. The other thing that we have to bear in mind is that we need to update the beneficiary designation or the ownership of the asset itself for non-qualified resources. Oftentimes, a trust will be drafted. There might be a revocable living trust where resources could be pushed in that direction. And that revocable living trust is drafted. There's a lot of thought that's put into it. It's very robust. It contains language that would apply to all kinds of different situations. If you had a beneficiary that might have special needs or might be under the age of 18 or age of majority, all kinds of different situations, lots of thought, might even have cost $5,000 or $10,000 to draft it. But if we don't get those assets put into the trust, then they're not going to be applicable. So it's got to be moving that account over into a trust account. Let's say you have an account that's a non-qualified set of resources, be that joint account or be that an individual account, and you have $1 million in that, and you want it to be driven by the provisions in the trust. Well, you need to retitle it towards the trust there, and that's such a key step that sometimes folks don't take, and that's one of the reasons why we really want to work hand in glove with estate planning attorneys for our clients to say, okay, you just updated all of these documents. Mr. or Mrs. Attorney, please tell us, how do you want those assets titled? How do you want the beneficiary designations titled there? Because we can take really good instructions and we can work with whatever custodian to make sure that they will receive it, because there are situations where a custodian won't receive actually, what's prepared by the attorney. And so we need to go back and forth to make sure that everybody's on the same page, because there's nothing worse than having that trust, where a custodian will say, well, we're not comfortable with, what's been drawn up there. You didn't have the right, designation listed, or we'll reject that.
Right. Absolutely. Okay. So while we're on this piece about the trusts, talk us through, what does it actually mean to fund a trust? Because I think that can be a rather confusing language point for folks. So what does it actually mean to fund a trust?
Well, the trust is set up, you execute the trust, it's out there, it's a vehicle that can have resources directed to it. It's kind of one of these containers. You think about going to Lowe's or Home Depot, and you get one of these large totes, these large containers, and you can put all kinds of different things inside. But if you don't put anything inside, it's just empty there. And that's kind of like the way a trust is. So what it means to actually fund the trust, oftentimes it will mean that you take non-qualified resources, be they in a joint account or be they in an individual account, and you will retitle those assets. So instead of you owning those assets, if you're an individual owner, what you would do is you would move those assets to being owned by the trust. Now, if it's a revocable trust, typically there's no change in cost basis in moving those assets into an account that's owned by the trust. Oftentimes what we would do is, with custodians, we would just set up a new account that would be owned by the trust. So the trust documents would have to be reviewed by the custodian. And account would be owned by the trust. Now, there's nothing in the account to begin with, but then you would take the individual accountants, just say you've got a number of different investments over here on this side that are publicly traded, stocks, bonds, ETFs, mutual funds, whatever they might be. You do an in-kind transfer of those assets. So the cost basis comes over. It's not a taxable event, typically. You fund that. And then now the trust is the one that owns those assets. Now, in a lot of cases with these revocable trusts, you still have the step up in cost basis when you pass away, because at the end of the day, those revocable trusts, typically the way they're drafted and the way they're looked at by the law is that all of the tax elements are still going to flow to your personal tax return. It's revocable, so you can change that at any point. We won't talk about the irrevocable trust, and some different things about that today, but that would be funding typically during your lifetime a trust. Now, you can fund a trust also after your lifetime. So you can point assets in those retirement accounts, you can point them towards the trust. So the trust ends up being the beneficiary of those accounts. So that's another way that you can fund a trust. But during your lifetime, again, setting up those assets and moving them across, that's the easiest way.
And again, we come back and we think about taxable brokerage accounts, real property, home, vacation, rental property. These are typically things that would be retitled to ownership of the trust, not 401k, not IRAs, because they can't be owned by the trust. They can be beneficiaries, but not owners.
Right. And so, you point out an important thing here when we think about the value of a trust. Oftentimes, one of the most valuable assets that a trust can own is out-of-state real estate. Because let's say you're a resident of the state of Tennessee and you own property in North Carolina, let's say you own a mountain home in North Carolina. If you pass away, typically, if those assets are not held in trust, your heirs are going to have to go through probate in the state of Tennessee where you resided. But then if you have North Carolina real estate, they're going to have to go through ancillary probate over there too. So they get the joy of driving to North Carolina and interacting with North Carolina courts to settle that piece of your estate. Oftentimes, what we'll see if we have out-of-state property is that out-of-state property will be put into that revocable living trust, such that you don't have to go through ancillary probate. The heirs would not have to do that. So that can be one of the chief values there, to just simplify your estate. And then, once they're named as a successor trustee, they can start to make decisions about that property as well. That is one of the benefits of having assets in trust. Oftentimes, decisions can be made a little bit more quickly because the successor trustee is named and recognized more quickly than, say, you can get to the courts, go through the probate process to start probate and get letters testamentary.
So Spencer, to close today out, how often should we really think about looking at our beneficiary designations and making those changes?
Well, you could look at this from a couple angles. First, anytime you go through a big life change, you should be looking at these documents. So let's just say, heaven forbid, something happens to you and you have a loved one, a spouse who's starting to go through cognitive decline. You want to look at the estate planning documents then. You have someone, a loved one, whether that be a beneficiary or whether that be a spouse who passes away. Obviously, you're going to want to look at the estate planning documents then. Really, anytime you have a named person, whether that be an agent who would be in place as a decision maker within the power of attorney document, or a beneficiary, or a trustee, anytime any one of those key people you start to look at differently, as maybe you've named a brother who would be a trustee should something happen to you and you have cognitive impairment, and that brother is a successor trustee. Maybe you've named a spouse as the trustee who would be the primary decision maker. Of course, there if something happened to you, but you've named a brother as a successor trustee, but maybe he's experiencing some cognitive decline, or maybe he just moved across the country and he's no longer the person that you want to have as your successor agent, as a power of attorney, or as a trustee. Anytime that you have one of those people in your life that's critical and that you've named as a decision maker or a successor or something like that, beneficiary, then you want to review this as well to see if an update is needed there. I think anytime that you touch a beneficiary designation, you touch your will, you also want to make sure that your estate planning attorney is talking with your financial advisor to coordinate any level of updating that's needed there with beneficiary designations. Because again, you touch the will and you update some things there, it can have a cascading effect, and you really need to make sure that the beneficiary designations are updated there too.
Right, absolutely. Well, Spencer, thanks for walking us through titling and updating your estate plan. Clients, if you have questions about your accounts in particular, how beneficiary designations are set up, or anything having to do with your estate plan, we would love to review those documents with you. As always, we'll see you again next time. Take care. If you like these financial planning videos, please share with a friend. And if you have questions, go to our website at SiriusRetirement.com. This content was provided by Retirement Planning Services. We are located in Knoxville, Tennessee. You can visit our website at SiriusRetirement.com. The information in this recording is intended for general educational and informational purposes only, and should not be construed as investment advisory, financial planning, legal, tax, or other professional advice based on your specific situation. Please consult with your professional advisor before taking any action based on its contents. Advisory services offered through Retirement Planning Services, LLC.